Coming up next on Arizona Horizon, ASU law professor Paul Bender joins us for a preview of the U.S. Supreme Court's current session, which includes cases on campaign finance reform, presidential appointment power, and affirmative action. A Supreme Court preview next on Arizona Horizon.
Arizona Horizon is made possible by contributions from the Friends of Eight, members of your Arizona PBS station. Thank you.
Good evening and welcome to Arizona Horizon. I'm Ted Simons. The United States Supreme Court session is underway with the High Court set to consider a number of intriguing cases in the coming months. Joining us for a special preview of the session is Arizona State University law professor Paul Bender. Always look forward to this show, Paul. Good to see you. Let's talk about recapping the last session and maybe doing a little comparison from what we can expect this session.
Well, you know, the last session was expected to be a real blockbuster session. They had three big cases at the end of the term, and one of them turned out to be a blockbuster, which was holding the Voting Rights Act, Section 5 of the Voting Rights Act, unconstitutional. And that's a really important decision. The other big decision that was supposed to happen at the end of the term was whether state bans on gay marriage were constitutional or not, and that one did not happen because the court decided it didn't have jurisdiction on that case. The lesson from that is you never can tell what's going to happen until the court acts. The court can decide these cases in a very broad, some of them in a very broad, meaningful, important way, and it can decide the same cases in a narrow way.
Is this a court that tends to go broad or tends to go narrow?
When they have the votes, they tend to go broad. People talk about Chief Justice Roberts as being a minimalist and a gradualist. That's not true. If he gets 5 votes for something that he wants to do, like Citizens United, or like hold that you can't use the Commerce Clause to support Obamacare, even though he said you could under another provision of the Constitution. If he can get 5 votes, he'll do it. And I think you'll see some of that this term. And there's something behind that. I think they realize, especially given the state of politics today, that there are probably as many solid conservatives on the court now as there are going to be in the next 10 or 15 years, because Obama's not going to appoint a solid conservative. And if the Democrats win the next presidential election, which looks like it's certainly possible, and that person has 2 terms, then the solid conservative bloc on the court may be at its high watermark. And it doesn't have 5, it's only got 4, and then there's Justice Kennedy, who votes with them most of the time, but even when he votes with them, he often moderates their view or moderates the view he'll agree to, so it's not nearly as broad as they wish. So if they see a chance to get something changed that they want to change, and it's part of the agenda of people like Roberts and Alito and Scalia and Thomas to reverse a whole lot of constitutional law that's developed over the last 30 or 40 years, if they get a chance to do that, I think they're likely to do it because they see if they can't do it now, they may never be able to do it.
Justice Ginsburg was recently quoted as saying this was one of the most activist courts in history. What do you make of that?
Well, first of all, I don't like that characterization of a court, activist or not. It doesn't really mean anything. All courts are activists in the sense that they do what they think is right, and if they don't do it, then they don't think they have to do it. What she meant by that, I think, was that this court, probably more than any other court since the mid-1930s, is willing to strike down legislation that a large majority of Congress has approved. That is legislation that most of the people seem to want. And I think she thinks it's activist in that sense. So what she was talking about was the Voting Rights Act case. The Voting Rights Act was reauthorized, Section 5, by Congress in 2008, I think. The vote in the Senate was unanimous, 100 to nothing to reauthorize. In the House, it wasn't quite 100%, it was about 98%. And the Supreme Court holds that unconstitutional. Now, that's remarkably activist in the sense of the court saying, we know what's right. The fact that Congress, everyone in Congress, thinks that something is necessary, we can just disregard that if we think the opposite. That's the sense in which she thinks they're activists, that they're willing to strike down the opinions of most of the people in the country. Same thing with Citizens United. I mean, the ban on corporations involving themselves in politics with corporate money is 100 years old, and nobody ever really questioned it. This court questioned it. They had the 5 votes to do it, and so they decided to get rid of that while they had a chance to. That's activist in the sense that she means that they'll reach out and grab an issue, and if they have the votes, they'll decide it, even if they are going against the Democratic majority.
If they have the votes, those 5 votes, that includes Kennedy. And
They
again,
would
it
need-
sounds like a Kennedy court still.
It is clearly still a Kennedy court. I mean, Kennedy is in the majority of almost every closely divided case. And every case, when you talk about it, you talk to lawyers about how's this case going to come out. The first thing they say, well, what's Kennedy going to do? Because it almost always turns on his vote.
Is that a healthy thing to have such a block of 4 and such a block of 4 and then 1 in the middle?
It's not so much the one in the middle. He's healthy in the sense that he's not firmly committed to any block. He tends to vote with the conservatives more, but he's an independent thinker, and that's the way they all should be. But when you have 8 of them, who these 4 almost always together on every issue, not every issue, but every issue with any political overtones, abortion, free speech, criminal defense rights, all kinds of stuff, equal protection, these 4 stick together and those 4 stick together. That's not healthy. You want to have 9 people who think independently, and you would expect 9 very smart people who think independently to find that they don't always agree with the same other 3 people.
Well, let's get to some of the cases here. We'll start with campaign finance reform, which I believe the court's already heard arguments or at least addressed
Last week,
yeah. What are we talking about here? This sounds like aggregate caps as opposed to... What's going on here?
What's going on, what potentially very important is what's going on, is that in the mid-1970s, when the court first dealt with campaign finance in a case called Buckley and Vallejo, which judged the constitutionality of a federal campaign finance law, the court made a distinction between expenditures in elections and contributions in elections. And it said that it is unconstitutional to limit expenditures. If you have the money, you can't be stopped from spending it in general. But they said contributions are different because contributions are just giving money. They affect speech, but they're not speech itself. So that you could limit contributions, although you couldn't limit expenditures. So what's been the law since then is that there are 2 kinds of limits, federal limits on contributions. There's called a basic limit, which is the amount you can give to a particular candidate. I think that's now $2,500 or $2,600 for any election cycle in a federal election. And the amount you can give to a party, to a state party, to a federal party, there are limits like that. If you gave the maximum you could give under all those things, if you were, say, a Republican and you wanted to support every Republican candidate for the House, every Republican candidate for the Senate, the Republican candidate for president, you could give like $3.5 million and still stay within those basic limits. So Congress has put an aggregate limit on it and said, yeah, you can give this much to a candidate, this much to a party, but your total contributions over a 2-year period, I think limited about $117,000. And that's what's being challenged in this case, not the limits on particular contributions, but the aggregate limit. And the argument is that how can the aggregate limit be necessary to stop corruption if I can give you a candidate $5,000 and that doesn't corrupt you? Well, I give another candidate $5,000. That doesn't corrupt him either.
On the landscape, $5,000.
That's right. So if I give them all, how am I corrupting anything? And the court said, the lower court said, look, in Buckley, the court said contribution limits are okay, and we're not about to overrule that. But the Supreme Court has taken that case. And the Supreme Court has felt, and this is one where Kennedy, I think it's pretty clear Kennedy wants to get rid of contribution limits. And so I would think that this is a good first step to do that. You get rid of the aggregate limits, and then the next step will be getting rid of the basic limits. So it's like Citizens United. This court is very comfortable with money being used to influence elections.
Impact of Citizens United on this particular case?
Well, I think you can argue that after Citizens United, any kinds of limits don't make any sense because corporations which have almost an infinite amount of money in election context can spend all the money they have to support whatever candidate they want. Once that's true, what's the point of limiting how much money you can give? Because you can't do anything like what General Motors can do. So I think the trend is very clear that this court, if Kennedy will join with them, is probably wants to get rid of all those limits on contributions as well as expenditures. And that's, that means money takes over politics.
Let's get to our next case here. This is regarding the president's recess appointment power, which is a hot subject back in Washington and touchy on partisan grounds here. But now the court's looking at this. What are they exactly looking at?
Well, it comes up from a National Labor Relations Board case. The president has had a lot of trouble getting his appointees, nominees to the National Labor Relations Board confirmed. And so I think in January of 2012, between the end of one session and the beginning of another session of Congress, he made 3 appointments to the Labor Board to fill out. There were 2 people already on there. He made 3, so there are 5. And the question is whether those 3 appointments are valid. If they're not, then the Labor Board has not been a valid institution since that time because they've only had 2 real appointees. And so what's at stake is not only this case, but potentially all the cases the Labor Board has decided since January 2012. This is a place where events have grown past the Constitution. When the Constitution was adopted, you had Senate and House sessions of 3 months, 4 months, 5 months, 6 months maybe, and the rest of the year was recess. And so most important federal positions have to be appointed with nomination by the president and consent by the Senate. Well, suppose that the Secretary of State or the head of the National Labor Relations Board were to die a couple of days after the Senate goes into a 6-month recess. You don't want to let that office remain vacant during that time. But it's an office that needs confirmation. So the Constitution has in it a recess appointment power, which says that vacancies that happen during the recess of the Senate can be filled up by the president with a temporary appointment, which lasts until the end of the next session. So if the Senate recesses on July 1st and July 10th a vacancy opens, the president can make a recess appointment, and that's good until the end of the next session, like a year and a half. And in that time, the hope was that they would confirm somebody. Well, what's happened, of course, is that the Senate and sessions go longer and longer and longer. There aren't 6-month recesses anymore, or even 3-month recesses. And also, the president has increasing problems getting people confirmed. The Senate will hold nominations, so nothing gets happened. And so there's been a lot of tension there, and there's been fighting back and forth. Presidents have started making recess appointments in things that really don't look very much like recesses. On the other hand, Congress has started saying, we're not recessing. And what they do, for example, these appointments were made on January 3rd of 2012. Early in December of 2011, the Senate said, we are now going into pro forma sessions. Every 3 days we will come back and say we're in session, and we will do no business for the next 3 days, and then we'll come back again and do it. Why every 3 days? Because the Constitution says that no House can adjourn for more than 3 days without the consent of the other. So from the beginning almost of December to near the end of January, they were pro forma in session. Well, the president said, I'm going to fill up these vacancies. One of them had existed for over 2 years. So the question is, can he act during that period? Is that a recess when the Senate says they're in session, but the Senate is not doing anything, and in fact they adjourn saying, we're not going to do anything for the next 3 days, and then we'll come back again and not do anything for the next 3 days. So the basic question before the court is, can the president act during those times?
What do you think the court's going to do?
I think it's interesting. In that case, the court added a question presented to the question that the parties had presented. And the question says, if the Senate does what I just described, that is pro forma sessions every 3 days, is that a time when the president can make recess appointments? And I think that shows that there's somebody in the court anyway, maybe 5 people, who are going to say, look, that's a phony session. That's really a recess. And so if you say you're only pro forma there, that should be treated as a recess and the president can make appointments. If they don't do that, they really are hobbling the president, not only this president, but any president, from filling up important posts for...
It's a de facto shutdown.
That's right. It's shut down of particular parts of the government. Like here, it would be a shutdown of the Labor Relations Board. So that's a case of tremendously important possible consequences.
We have another affirmative action case here, this one involving Michigan and a ban on affirmative action. Is this an important case?
It could be. It's important for Arizona because we have the same ban in Arizona I think it's Section 35 of Article 2 of the Arizona Constitution, which, when you read it, you don't think it does very much, because, at least I don't think it does very much, because it says that educational institutions in the state that are run by the government, and the state generally, cannot engage in discrimination on the grounds of race or giving preferences on the grounds of race. Well, when I read that, I don't think that that applies to affirmative action programs at a university that are intended to diversify the class at the university. That's not discriminating against anybody. It's not giving a preference to anybody. The university does it for their own educational purposes, not to prefer somebody. I mean, when you give alumni children a preference, that's to prefer alumni children. But this is for educational reasons. But the Michigan proposition, which is word for word the same as the Arizona one, has been accepted by everybody as a ban on affirmative action programs. And so the issue before the court is, can a state constitutionally tell its educational institutions, you may not engage in affirmative action for the purpose of diversifying the class, something the Supreme Court says you can do, but the state says, well, maybe we can do it, we don't want to do it. And the lower court there held an en banc opinion in the Sixth Circuit that I think came out 8-6, that was unconstitutional because it put a special burden on minorities. If minorities wanted to get some relief or benefit from the admissions process of the universities, they couldn't. They have to go to the people and get a constitutional amendment. If athletes want to have a preference for football players, they can go to the college admissions committee and get that. If alumni want to have a preference for their children, they can do that. And so the Sixth Circuit said that's a discrimination against minorities because it makes it harder for them to get their interests served than it does any other group.
When the court looks at something like this and they look at a voter-approved measure, does it make any difference at all if it's voter-approved as opposed to coming from the legislature?
No, it doesn't.
Okay.
It doesn't. The voter-approved measure doesn't get any special consideration. The court decided a couple of years ago, in an opinion by Justice Kennedy, by the way. So no, that doesn't play a role. But I think the court, you have 4 people on the court who don't want to have any race-conscious affirmative action, the 4 real conservatives. Kennedy doesn't like affirmative action, but he has been willing, as O'Connor was, to say that it can be used in some circumstances. And so if you have 4 people on the court who think all affirmative action is unconstitutional, they're not about to vote to say that the state has to permit affirmative action because they think it's unconstitutional. The question is, what's Kennedy going to do?
What is he going to do?
I would suspect that he would vote with the conservatives on this one and say that a state is free to choose not to have affirmative action and free to choose to have it. It's a question that's up to the state to make a decision. Interesting.
All right, we have another case involving picketing limits at abortion clinics. Talk to us about this.
This is another case. This session seems to be full of these possible ones where they could. Why did they take this case? Years ago, they decided that it was constitutional for states to establish sort of no picketing zones around abortion clinics. They had a case, I think, where you couldn't get within 100 feet of the entrance to an abortion clinic and confront women going in to get abortions by telling them they shouldn't do that. That it was constitutional to keep those people out of that zone so the women would be free to go in without being harassed. This case is a Massachusetts 35-foot zone around the entrance to abortion clinics. And the lower court says, hey, we've already decided this. The Supreme Court's already decided this is constitutional. And the Supreme Court grants cert in that case. Now, why did they do that? Are they really about to hold that it is now unconstitutional to stop people from harassing, going in the face of people who are going into a medical facility? Otherwise, I don't understand why they took the case. So that could be a very big change, and it also could be very closely divided because I'm sure there are 4 people on the court who would not want to do that.
And again, they're calling this sidewalk counseling, impedes the ability to communicate with their intended subjects here. Again,
they say they have a right to face-to-face close confrontation, that if they have to stay 35 feet away, they can shout, they can offer literature, they can hold up signs, but that's not enough for them. They want to get right in the face of the women and say, you know, you shouldn't have this abortion. And they say that violates their free speech rights.
So again,
let them do that.
If that Colorado limit, this 100-foot limit in Colorado, if that's okayed by the Supreme Court,
Well, that's what the lower court said. Massachusetts is 35 feet, so how can that be bad?
Yeah.
And then the Supreme Court takes the case, so it leaves you scratching your head. as to what's going on. This court is very strong on free speech. And Justice Kennedy is very strong on free speech. So it wouldn't be beyond possibility for the court to reconsider those decisions and say that the Constitution requires letting anti-abortion protesters have a right to directly confront people going into abortion clinics. That seems to me to be wrong. I think the right of somebody who's about to have a serious medical procedure to be able to do that with a peace of mind should prevail over the right of somebody who wants to talk to them, even though the people they want to talk to don't want to hear from them. But the fact that the court takes the case suggests that they may be reconsidering that.
How is this court when it comes to search and seizure cases? We've got a couple of them this go around.
Yeah. Search and seizure is something that some people on the court, Scalia primarily, who you would think of as conservatives who wouldn't sympathize with criminal defendants, occasionally vote on the side of criminal defendants. Last term, for example, the court had a couple of dog cases involving the use of dogs smelling for drugs, and police took a dog up on the porch of somebody's house to sniff under the door to see whether there was marijuana there, and this dog sniffed and found marijuana, and the question was that an unconstitutional search? And Scalia wrote an opinion saying, yes, it was unconstitutional, that to take a dog on somebody's porch is enough of a breach of privacy. That's not 100% clear that that's the right answer, but that's one of the close cases where occasionally the court will decide on the criminal defendant's favor. This year they have two cases which are both kind of interesting. One is a guy is suspected, I think, of murder, but they don't have enough to get a search warrant to search his house. So they go to the house and they knock on the door, and a woman answers, and they say, is anybody inside? And she says, no, nobody's inside. And then this guy pops out and he says, no, I'm inside and you can't come in here. I want you to stay out. So the police say, who are you? And he tells them they arrest him, okay, because they think they have probable cause to do it. And they take him away. And then they go back to the woman and say, hey, can we come in? And she says, okay, you can come in. And the question is that a constitutional search? Assume they don't have a warrant. They would normally need a warrant unless they get the consent of the tenant or the owner. Well, one of the tenants said, don't you come in here. And the other one, after they took him away, said, you can come in here. The question is whether
the co-tenant overrides?
The co-tenant can override him. And there's some cases about that which suggest that the co-tenant cannot override him if he's there. But the lower court case said, well, that's only if he's there. And once they take him away, she can do anything she wants. So that's one where I would think the chances are the court will say she can override him, especially since they've taken him away. The other case involves an anonymous tip that there's somebody driving recklessly. He just forced me off the road, and his license plate number is so-and-so, and he's driving a Ford such and such. And that comes into the police. They don't know who made that tip. And the police forward it to police who are out in their patrol cars, and they say, hey, look out for a Ford with this license plate number. And they find the car, and they follow it for about 5 minutes, and it drives perfectly reasonably. And then they stop him. They stop the car, and they say, you know, show us your license and stuff like that. And they go back to the car to check the ID, and then they come back to the car, and they smell marijuana. And so they say, get out of the car, and they find drugs in the car. And so the question is, was that stop legal? The police who stopped saw absolutely nothing that was suspicious. They stopped on the basis of an anonymous tip that had been transmitted to them over the police radio, but they knew it was an anonymous tip. And so does that kind of tip provide a basis for stopping the car when the police who actually stop it don't see anything going on that would justify stopping the car?
What kind of corroboration would be needed then?
Well, if the car was driving erratically.
If that particular cop saw the car.
That's
driving.
right.
Not if he heard. But what happens to radio communications in a case like that?
Well, there's radio communication, but the question is, somebody said the car was driving erratically.
Yes.
We don't know who said that.
Yes.
So do we, on the basis of that anonymous tip, when we don't know where it came from, it could have been somebody who's out to get these people.
Yeah, set them up or something.
Yeah, so is that enough to justify the stop of a car?
What's the court going to do on that one?
I would think the court will probably, why are you asking me the question?
That's what we got you on the show for.
Yeah, I would guess that the court would say that that's enough in that situation, because there's enough of a chance that the people are driving in a reckless way that they would want to resolve doubts in favor of safety.
We got about 30 seconds left. There are even more cases out there, chemical weapons, just strange stuff out there.
Yeah.
Is there a case that you think more than like 30 seconds here now, lasting political, lasting social impact? Which one?
Of all the cases we talked about?
Yeah.
Well, I think the lasting political impact is probably the recess appointments clause. If the court says that the president cannot make recess appointments during those periods when the Senate is formally in session but not really in session, that has a big political impact of giving the Senate the opportunity to frustrate the president's agenda by refusing to appoint any people. So I think that is political impact. And if they really are about to get rid of contribution limits, I think that can have a big political impact also.
All right. Great stuff as always. Thank you so much for being here.
Glad to be here, Ted.
And tomorrow on Arizona Horizon, a look at controversies and concerns involving the Arizona Medical Board. And we'll talk to local author Jana Boomersbach about her new children's book. That's Tuesday evening, 5:30 and 10, right here on Arizona Horizon. That is it for now. I'm Ted Simons. Thank you so much for joining us. You have a great evening.
Arizona Horizon is made possible by contributions from the Friends of 8, members of your Arizona PBS station. Thank you.